Okay, today we're going to pick up with some more information, especially about amendments dealing with the judicial branch and some of the major decisions that have affected what happens with court cases. So today we're going to pick up with the Fourth Amendment. And the Fourth Amendment, which you know, deals with unreasonable searches and seizures. But there are certain things that it does not do. For example, it does not define what is unreasonable, and it does not say what should happen if the amendment is violated. So how to correct things. So there's two Supreme Court cases that deal with this. And the first one is the case of Weeks versus the U.S., which takes place in 1914. And what happens here is Fremont Weeks is suspected of using the mail system to send out what essentially turns out to be like lottery tickets, but gambling was illegal in Missouri at the time, and so he was committing what was essentially mail fraud. And so the officers in charge of the investigation searched his home on two different occasions, and both times took evidence. But neither time that they searched was Weeks served with a warrant. And so the evidence that they obtained was gained illegally without a warrant. And so the case of Weeks versus the U.S. is going to establish the exclusionary rule, which means that if evidence is gained illegally, it will be excluded from the court case. It can't be brought in as evidence. It can't be used for anything. So it's basically a waste. But it only applied in federal cases. So the next case is Mapp versus Ohio. And Mapp versus Ohio kind of follows the same thing, where illegal evidence was obtained because they didn't use a search warrant, an appropriate search warrant, and so evidence will be excluded from the trial. And the reason this case is important is because it's going to expand the exclusionary rule to the state and the federal cases. So it's not just federal cases, it's also going to apply to state cases as well, which is going to open it up quite a bit. So both these cases deal with, okay, what's a reasonable search, what can a search warrant, or what does a search warrant need to be used for, what can it be used for? And so in terms of a reasonable search, the best answer is that when you have a reasonable expectation of privacy, like in your home or in your car, you need to get a search warrant, or basically, when in doubt, get a warrant. And so that's kind of the rule of thumb that police officers go by. So what's a search warrant? Well, search warrant basically says that they need to look through your place because you're under suspicion, or the place that they're looking for is under a suspicion of being involved in a crime. And what the officers do is they contact a judge, and there's always one that's on call for 24 hours. The judges rotate whose turn it is. And the judge needs to be convinced by the officer that a warrant is justified. Now, the warrant needs to list the name of the person involved, where they're looking, and what the officers are looking for specifically. So if in their search warrant they don't include, say, an outbuilding or a garage in their search warrant, the only place they can search is your home. They cannot search in the garage if it's not a part of your home, if it's a detached building. Now, there are some cases where warrantless searches are allowed, and this is a search that does not need a warrant, kind of self-explanatory. But basically what happens with a warrantless search is that the police have to have probable cause to suspect you of a crime, so they can't just waltz in wherever they want. And the police are lawfully in a place doing something that they are lawfully permitted to do. So this would include things like custody battles, custody arrest, where someone has stolen a child kind of thing. Anytime they do a stop and a frisk to see if you have illegal weapons, if they come across illegal drugs at the same time, then that is considered a warrantless search, that they were already looking for something that they're legally able to do, and they came across something else. Any search that an owner consents to. So if they're at home and they ask if they can search the home and the owner says yes, then anything they come across is okay because they had consent of the owner. Anything that's in plain view, like if it's in the back seat of your car. If you're under 21 and if you got a six-pack in the back of your car, it's in plain view. You don't have a reasonable expectation of privacy in that way. If it's in your trunk, that's a whole different thing, because that's not in plain view. So they'd have to get a warrant to search your trunk, but they'd have to have probable cause in order to do that. So you see how this gets to be sort of complicated. The next two amendments are the Fifth and the Sixth Amendment, and we've talked a bit about the Sixth Amendment when it comes to the jury, but we're also going to look at some other things that are included in that as well. So the Fifth and the Sixth Amendment will start right away from the beginning of a crime, and that's when the arrest takes place. Officers are required to read a warning to you, and that warning is you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be appointed to you by the state of whatever it is, in this case Iowa. These are called your Miranda rights, and this requires officers to issue this warning to you so that you know your rights before you are arrested. And this comes from the case of Miranda versus Arizona. Ernesto Miranda was arrested for robbery, and in the process of his questioning, he confessed to a rape while he was in custody. And he was convicted of the rape based on his testimony and the identification by the victim. However, he had not been told that he could ask for an attorney during questioning, so he did not know his rights. It's probably a good thing to know at this point that he was also mentally disabled, so he probably did not actually know his rights. And so because of that, there's a new trial, and it's based just on the evidence that was collected, and he will be convicted not of the rape, but he will be convicted of the robbery. And so, but we do get this appeals process, and so there's many people out there who probably don't know what their actual rights are, that you can have an attorney during questioning. It's not just during the actual trial. And so several cases will come up that deal with those kinds of things, of what your rights are. The next major case is Gideon versus Wainwright, and this is going to rule that any person who is too poor to hire a lawyer cannot be assured of getting a fair trial if they just get somebody off the street or they try to represent themselves. And so this case decides that lawyers are not luxuries, lawyers are necessities when it comes to a trial. Other things that will be included in the Fifth and the Sixth Amendments are things like self-incrimination. The Fifth Amendment protects you from saying that you are guilty. You never at any point have to say that you are guilty. The prosecution instead must prove your guilt. It is not you proving your innocence. It's one of the benefits of living in the U.S., where you're innocent until proven guilty, rather than guilty until proven innocent. Whole different mindset. Another thing included in there is something called double jeopardy, and this protects you from being convicted of the same crime twice. It does not protect you from being tried for the same crime twice. If you just look at the Miranda case, he had several trials for the same thing, but it does protect you from being convicted of the same thing twice. Now, the role of the county attorney after the arrest is to decide what the person is going to be charged with. So they study the evidence, and then they prepare a case and put it together and decide what you will be charged with. And the 14th Amendment is going to deal with some of those ideas as well, of how a trial is processed through the system. One of the things included in the 14th Amendment is the grand jury, and this is going to be summoned in order to determine if there is enough evidence to bring formal charges. And usually this is only used in like felony cases, like murder, kidnapping, those kinds of things. The really big stuff. And a grand jury is typically anywhere from 6 to 12 people. They don't actually decide if somebody's guilty or not. All they're saying is, yeah, there's enough evidence that we need to look at this a little bit closer. And they decide if there's going to be a trial. The indictment usually comes out after the grand jury makes their decision, and the indictment is a formal written accusation that is brought against the accused, saying, we believe that you committed this crime. We accuse you of this. And so that will be presented at the arraignment. And the arraignment is when the accused is brought before the court, usually before just a judge, and formally notified of what the charges against them. At that point, the accused enters a plea, usually of guilty or not guilty, and bail can also be set at that time. The Sixth and the Seventh Amendments then deal with things like the jury selection. The summoned jurors fill out a questionnaire. They determine any pre-existing prejudices or knowledge of the case. And each side, the prosecution and the defense, can both hire a psychologist to actually help out in jury selection to decide if people are prejudiced or not, to look for those telltale signs. The trial procedure itself starts with opening statements. The prosecution goes first and then the defense goes. And each of them are outlining their side of the case. They're giving kind of a brief overview of what they're going to be looking at. The trial timeline, each side brings forth witnesses to back up their side of the case, and they are able to cross-examine or question the opposing witnesses. The defense attorney is going to present the defendant's case. The defendant does not have to testify on their behalf. So if you are ever accused of a crime, at no point do you ever have to take the stand. It's up to the prosecution to prove that you are guilty. By the end of the trial, we have closing statements where they summarize and argue the points in favor of their side. So they really want to hit their strong points. Now, throughout the course of the trial, both attorneys are able to do something called an objection. And this is where they can object or they have a problem with a certain line of questioning that the lawyers are doing during their cross-examinations. The judge in this case has the ability to either sustain an objection or overrule it. When he sustains an objection, he is agreeing with the objection, and he asks the lawyer to redirect or to reword the question. If the objection is overruled, he is disagreeing with the objection, and the questioning is allowed to continue. After the trial is all completed and they come up with their verdict, the Eighth Amendment then comes into play, and the Eighth Amendment is the sentencing of the person found convicted of the crime. And the Eighth Amendment, a lot of debate has gone on about cruel and unusual punishment. What does it mean? How does it apply? Why hasn't it been consistent throughout our history? So there's a lot of things that go into that. Eventually, if you do not like the decision that the court came to, you can appeal your case. If you are not satisfied with the decision, if you don't think that they came to the right decision, the right of appeal is available. And this is going to attempt to correct any problems within the court's decision. Perhaps you thought your lawyer didn't do a good enough job, or that there was faulty evidence, or there's new testimony that could perhaps clear you of your sentence. So when that happens, the appeals court can do three things. The appeals court could affirm the decision, which means they uphold the decision of the trial court, saying, nope, they came to the right decision, and that's the end of that. Or the appeals court could reverse the decision, which means that they are going to basically overthrow the decision and nullify the trial court results. The third thing that they could do is the appeals court could remand the decision. And remanding it means that they're going to send it back to the trial court to be done all over again. So they're not saying you're right or wrong, just here's another go at it, see what you come up with this time. And so that's just kind of in a nutshell the judicial system.